In the very first line of the opinion, the judge writes that sometimes truth really is stranger than fiction. And here, the Fourth Amendment claim is destroyed by an 8-year-old who tells the police, and I quote, "He put something in my room, bro, and I don't know what it is." Well, that something turns out to be a firearm. And later, this case goes to appeal where the defendant is claiming to be an overnight guest. So today, we're going to talk about the Fourth Amendment, what it means to be an overnight guest versus a stranger in somebody's home, because the standing or the level of protection by the Fourth Amendment changes depending on your title. Before we go on, I want to thank you for watching me here on YouTube. If you're new to LAWSTACHE channel, hit that subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to shop.lawstache.com and check out some of the merch, including the Do Not Arrest This Person t-shirts. Thanks for watching, and let's talk about the Fourth Amendment.
Quick message from LAWSTACHE. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vieltsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the LAWSTACHE YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the LAWSTACHE YouTube page. That's LAWSTACHE.
Today we're discussing a case decided just this week on June 8th, 2026 in the 8th Circuit, and it is United States versus Gatkuoth. But first, let me give you some factual background. We're in Omaha, Nebraska. Police officers are trying to pull over Mr. Gatkuoth, who just rolled through a stop sign. So a routine stop. But it quickly becomes not so routine. Rather than pulling over, Mr. Gatkuoth proceeds to flee. He rolls through another stop sign. Eventually, he pulls over, jumps out of the car, and runs into a nearby home, clutching his waistband. The officers follow, they go through the door. After a short standoff, Mr. Gatkuoth gets arrested. The officers then hear a child's voice from the bedroom. They go in, they talk to an 8-year-old who tells the police officers, and I quote, "He put something in my room, bro, and I don't know what it is." The officers then search and they find a Taurus 9mm handgun hidden within the laundry inside a hamper. Well, Mr. Gatkuoth gets charged and being prosecuted for being a felon in possession in violation of 18 U.S.C. 922G1. He then files a Fourth Amendment motion trying to suppress the firearm, saying that the officers needed a warrant in order to search that particular room. He says that he was an overnight guest at this particular home. So the officers needed a warrant prior to searching that room. Of course, the officers did not have a warrant in this case. But before we talk about the law, enter the porch guy and the credibility disaster that followed in the trial court. Now that you've heard all about the chaos, the chase, and the standoff, there's one more fact that I need to mention. While all of this was happening, a resident was calmly standing on the front porch of his home. His name was Mr. Kwani. Now, after Mr. Gatkuoth gets arrested, the officers ask Mr. Kwani if they know each other. And Mr. Kwani says, "Nope, I don't know the guy, have never met him before." Now fast forward to the suppression hearing, the story changes. All of a sudden, Mr. Kwani testifies they have been a long time friends. They're in the same gang, and in fact, Mr. Kwani has extended an invitation to Mr. Gatkuoth to always stay at his home. And in fact, he has been an overnight guest many times. But the district court judge characterized the testimony as, in quotes, less than convincing. And here's why, for 4 reasons. Number 1, nobody else at the home knew who Mr. Gatkuoth was, which is problematic given that the testimony is that Mr. Gatkuoth often stays at the house. Number 2, after being longtime friends, Mr. Kwani could barely say anything about Mr. Gatkuoth. It seemed like they barely knew each other. Number 3, the district judge said that the testimony seemed rehearsed, that some of the things that Mr. Kiwani said he could easily remember, but some questions he really struggled with. And finally, number 4, Mr. Kiwani had a prior conviction, and this is the most problematic conviction. It is for falsifying or filing a false police report. So for those false reasons, the district judge did not believe Mr. Kiwani and denied the suppression motion, meaning that the firearm entered and Mr. Gatkuoth eventually proceeded to trial with firearm being admissible. Mr. Gatkuoth lost the trial and appealed to the 8th Circuit. So here's where we are now. We're in the 8th Circuit and he's appealing that prior decision to deny the suppression motion. Now we're ready to discuss the law. The 4th Amendment protects you against unreasonable searches and seizures, and generally speaking, officers need to have a warrant before they conduct a search or seizure. Of course, here we have a search. We have police entering a home and later a bedroom where they find a firearm, which is clearly a seizure. And of course, they do all of this without a warrant. But before we get there, the individual who's claiming a violation of the 4th Amendment has to show standing, meaning that these are personal rights. He has to show that he had a reasonable expectation of privacy in the place to be searched and the items to be seized. Now, we have previously discussed the difference between being an owner of the property versus a tenant, the difference between a house or a hotel room. There are many cases on the topic. And believe it or not, overnight guests can in fact have a 4th Amendment protections because they have a reasonable expectation of privacy in the place they're staying at. This is the reason why Mr. Gatkuoth's attorneys are pushing so hard on the fact that Mr. Gatkuoth was an overnight guest at this property, because then he has the 4th Amendment protections and a reasonable expectation of privacy in the place to be searched. So at the 8th Circuit, the court has now a mission to decide whether Mr. Gatkuoth had standing and whether the suppression hearing was conducted properly. But the standard of review at the appellate level is clear error. So we're not asking the question whether you would believe that Mr. Gatkuoth was an overnight guest or not. It is not the question whether you think Mr. Kiwani was credible or not. The question is whether we believe, or the appellate court believes, that the lower level judge made a clear error when he deemed Mr. Kiwani not credible. Based on this standard, the appellate court says no, the district judge made a proper decision. He was not clearly erroneous when he said that Mr. Kiwani was not credible. So the suppression decision stands. And so the gun could in fact enter trial. For those reasons, we now move on to another claim that Mr. Gatkuoth makes. He says, what about the fact, how could the jury even decide that this was my firearm? This is the only thing that he has left. The firearm was properly admitted as evidence. And so he says, prove to me, how was this my firearm? And so looking back at the record, the 8th Circuit says for 3 reasons. Number 1, it is rare for somebody to store a firearm underneath laundry in a child's bedroom. So it is okay for the jury to believe that most likely the firearm belonged to somebody else. Number 2, the individual, Mr. Gatkuoth, was running, clutching his waistband. So that's another fact. And finally, it is the 8-year-old's testimony and the statement to the police that destroyed the facts of the case. He said to the officers that Mr. Gatkuoth hid something in his room. And that something turned out to be a firearm. So for those three reasons, the jury could in fact find Mr. Gatkuoth guilty of the crime of being felon in possession of the firearm, because he in fact did constructively possess this firearm that was left behind in the bedroom. So what do we learn from this case? Number one, the Fourth Amendment is personal, meaning that you have to show that you have reasonable expectation of privacy or standing before raising the claim. We also learned about credibility. The judges can look at the credibility of the witnesses at the suppression motions, at the suppression hearings. And here, the judge said that Mr. Kwani was not credible. So we know about the Fourth Amendment, we know about standing, about credibility. Of course, when we're talking about credibility, it is also the credibility of the 8-year-old who said that something was hidden in his room. So I hope you enjoyed this case, and if you did, give this video a thumbs up. If you're new to LAWSTACHE channel, hit that subscribe button. If you're listening to the podcast version of this recording, Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to shop.lawstache.com and check out some of the merch, including the Do Not Arrest This Person t-shirts. Thanks for watching, and I'll see you next Wednesday on another deep dive on another criminal case. Thanks for watching.